Hi everyone, this is the group assignment on the business and corporation law. The students doing these assignments are Utsav Khadka 2238, Raman Maharjan EMV 21022, Suman Giri OED 2116, Alice Bista OED 2188, and Kemaraj Rai EMV 21698. As we have decided to do the Berk and Winston case, as this case is one of the famous case in Australia. This case arose in 2013 and the dispute was between the plaintiff Tamar Berk and defendant Amira Winston, both the siblings, and the reason was the validity of the preference share and its nature, if the company have issued the ordinary shares or not. Well, to go in the past, it already happened during the incorporated year of LW Furniture Consolidated Limited in 1971. The company decided to categorize its shares, where the C-class shares were considered as the redeemable preference share, which was issued to the founder director of the company, Mrs. Hedy. The C-class redeemable share was supposed to be redeemed to the company. After the death of Mrs. Hedy in 2004, the company attempted to redeem the C-class shares, which was objected by the plaintiff, Tamar Berk, with a claim that there is no existence of preference share without ordinary share. However, in the end, the court held that there is the presence of the preference shares, even though there is no existence of the ordinary share. This case was lengthy and moved from Supreme Court to High Court, resulting to the same decision of preference shares being valid under the provision of Company Act 1961 New South Wales and the Corporation Act 2001. The later of the depth of the case will be described by my friend. Thank you very much.
Hi, my name is Alice Bista, student number OED 2188. So continue about the Berk and Winston 2013. I will be talking about relative facts. Well, a brief summary more, like the case was like this case. The court held that private companies may issue preference share even if they have not issued and do not ever issue any ordinary cases. This case was lengthy, as my friend already said it. This case went from Supreme Court to High Court, so we can imagine how lengthy this case was. That's why like most of the people in Australia, they know about this case. It was a dispute between two siblings. Matter of fact, it was a debate for a money or for a share between two siblings. Moreover, as we knew, like Hedy died in July 6, 2004, Berk still challenged the validity of share redemption in NSW Supreme Court. The HC shares were issued to Hedy and one each to Amiram Winston and Tamar Berk. Weinstock purported to redeem the HC shares held by Weddy's state at $1 per share. 10% of these shares are classified as A Class C, also known as a preference share. LFW's article said an unauthorized capital of $20,000 divided into 20,000 shares of $1 in 1971. Moreover, High Court considered the meaning of a preference share under equivalent provision of Companies Act 1961, NSW, and Corporation Act 2001 CDAs, as my friend said it earlier. We can see that there were three different judgmental striking differences in statutory interpretation and general legal reasoning. So this case was lengthy. So this case was interesting. And so this case was one of the world-renowned cases in Sydney, Australia. So passing to my friend, he will be talking about more about the cases and like plaintiff and defendant of the cases. So thank you very much for listening to me. Thank you very much.
Hi everyone, my name is Kemaraj Rai and my student ID is EMV21698. Today I'm here to discuss about the group assessment of business and corporate law, and my title is Plaintiff versus Defendant. According to the plaintiff Tamar Beck, she sought a declaration that Harris 8C shares were not validly defined as preference shares under the Corporation Act 2001 CST. Furthermore, she claims that preference shares would have no meaning in the absence of ordinary shareholders. However, refusing the opinion of plaintiff, the defendant Amiram weinstock held the point that directors must still have regard to their duties in approving or redemption of redeemable preference shares. Thank you. The remaining part of the presentation will be explained by my group members.
Hi everyone, my name is Suman Giri and I'm here to discuss about business and corporate law assessment. Today I'm gonna present about status applied. Status applied mainly focused on Hene, Kreman and Keifel JJ, Gagler J and French CJ. Hene, Kreman and Keifel JJ discuss about the joint judgment which was mainly focused on 1961 Act. Their honor views this clause as a granting LWF board freedom to issue preference share. On the 1961 Act 61, the company provided may if also authorized by its articles. Gagler J, which was mainly focused on this Act 2001 and barely mentioned the Act 1961, held the LWF was a free grant such as contractual right at any time. French CJ mainly viewed on the Act 2001 as establishment a generic platform rather than constructing rules for the preference share. Considering preference share as a device for shaping to the overall corporation entirety rather than a bare expression to the particular contract existing between LWF and Handy. I would like to hand over my presentation to my colleague. The rest presentation will be explained by my friends. Thank you.
Hi, I'm Roman Maharjan and I'll be continuing the presentation as for the berk and weinstock. As for the conclusion for this study, the specific protection of a company capital which attract to the redemption of redeemable preference share do not logically require that such shares only be brought into existence after ordinary shares have been issued and only redeemed while there are ordinary shares in existence. So for this case to be validated, the ordinary shares need to be existed for them to be validated. Thank you. This is the end of our presentation.